Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, Why Mediations Fail and How to Achieve Better Results. This event is brought to you by National Arbitration and Mediation and sponsored by Law.com. Before we begin, let's go over some basic housekeeping items about the webcast console. First, this event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console. You don't have to open a new browser to do so. Just scroll along the bottom of the screen and click on the social networking widget of your choice. In fact, we encourage you to do so. If you have a question for one of our speakers, please enter it in the Q&A widget on your console. We will get to your question during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so we invite you to ask away. If we don't get to your question, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So if you'd like to change the look and feel of your console, go right ahead. And finally, we have several resources available for download in the Resources tab of your console. In addition, the presentation will also be available for download. Also, this event has received CLE approval for the states of California, Illinois, New Jersey, and New York only. Participants who wish to receive credits for other states must check directly with their CLE board. During this presentation, the CLE code will be announced. New York and New Jersey attorneys should retain the code for their records, since they will need to enter it in order to download the CLE certificate post-event. And now, for today's topic and the reason you are all here. The majority of disputes resolve at mediation. Nonetheless, there remain those that impasse. Failure to achieve resolution can often be avoided if advanced adequate thought is given to common potential pitfalls, which include ethical issues that may arise. Here to explore the reasons why mediations fail and how to achieve better results are Richard Byrne and Casey Laffey. Richard is mediator for NAM, and Casey is a deputy practice group leader of Reed Smith's Complex Litigation Group. So without further ado, I will now go ahead and turn it over to Richard, who will kick off today's discussion. Richard?
Well, thank you, Kelly, and thank you all for joining us this afternoon. I'm very pleased to be here with my colleague, Casey Laffey, and we're hoping to give you kind of an interesting perspective to be able to talk about these issues from my perspective as the mediator and from Casey's perspective as a commercial litigator. So we're going to follow the format of the slides, which you will see on your desktops or laptops before you. But as Kelly mentioned, please feel free to send in any questions. I know they'll be curated to some degree, and we'll try to get it to as many as we can, including those that were asked before we began this afternoon. So let's begin. We're going to be talking about why mediations fail. And, again, I certainly hope you are all believers in the process, as I am, and know from experience that most cases do resolve at mediation, but there are some that do not and end up at impasse. And what Casey and I are going to talk about this afternoon is, well, why does that happen, and what can be done to avoid that unfortunate outcome. So as you can see, slide number 1, lack of preparation. So when I was a young lawyer, I would hear the old adage that cases which get prepared for trial settle, and cases which are prepared for settlement get tried. And like any adage, I think there's truth in that statement. And I certainly encourage all of you on that spectrum to treat mediations much more akin to trial with, as we mentioned in the slide, preparation, preparation, preparation being the mantra. And why wouldn't you prepare? You're certainly paying good money. It's an investment financially to have a mediation. It's certainly an opportunity to impress your adversary. It's an opportunity, quite frankly, to impress the mediator, because even though, of course, we are neutral in the process, we're also human. And candidly, those that come in more prepared are going to have greater credibility with me. I always suggest, please don't use the mediation process as a means to buy time or as a vehicle for, the thought, well, I'll get some free discovery out of it at the very least. come to the process really with the good faith goal of trying to get your matter resolved. Put the time in up front, invest that time, and as a subset of this item, I'd also mention take the time to prepare a written submission. I will certainly tell you that I read my written submissions from cover to cover. Oftentimes I'm asked, well, do you have page limitations? Do you have exhibit limitations? And my answer is, if it's important to you, it's important to me. And I will not bind the parties with artificial limitations. Again, if you think it is important, I will read it. I think it helps you focus in your preparation as you pull together all the information and documentation. Again, part of the mantra of preparation, preparation, preparation. It helps you pull your thoughts together, the issues together, the documents together in advance and in part of presenting the submission to me. Now, I do say if it's important to you, it's important to me, and I will read that which I am provided. However, please do not use it as an opportunity to do a document dump. I do see that from time to time. I'm not really thrilled when that happens. For example, I may get a written submission that says, well, the plaintiff's testimony on this point was X, Y, and Z. Please see attached deposition transcript. Well, candidly, I'm not going to read the deposition transcript. However, if you take the time in preparation to make that point and then say, please see pages 56 through 58, lines X through Z, and you attach those excerpts, yes, I will read those. But again, I do think this is an investment. You will get as much out of the process as you put into it, and preparation is very important.
Yeah, Richard, this is Casey. First of all, thank you and Nam for having me, and thanks everyone for joining. I couldn't agree more. I mean, I think I've seen repeatedly a common mistake in mediation with lawyers just not being prepared to address the other side's arguments, to prepare your weaknesses, or at least your alleged weaknesses. What I try to do in advance of a mediation is I actually try to sketch out all of the other side's arguments, what I anticipate they're going to argue, and I actually sketch out my best responses and really try to come up with the best documents that support those responses and maybe the best case law. For example, if you know you're on the plaintiff's side, you have a very strong case on liability, but you know the defense is going to be focusing on the alleged lack of causation. Don't just gloss over that and focus on liability. You've got to change the adverse client and your adversary's view of your weaknesses on causation. Come ready to address causation. Come ready with your best documents on causation. Preparation is key, as Richard said, and I can't agree with that more. You really have to think critically about your own case. Put yourself in your adversary's perspective and be ready for the mediation. And turning to the next slide, speak to your mediator early and often. And I'm a big fan of this, and this dovetails nicely with the aspect of preparation. And many attorneys just do not take advantage of the opportunity to speak to the mediator in advance of the mediation. Obviously, you're going to have time the morning of the mediation and at various times at the mediation, but even if your mediator doesn't voluntarily offer to discuss the case with you, reach out to your mediator in advance. Feel free to do it multiple times. I like to speak to the mediator in advance to talk about not only some of the key issues that I think the other side may be struggling with writing a check if I'm on the plaintiff side, or vice versa if I'm on the defense side, also to talk through with the mediator certain dynamics. Is there a dynamic personality on one side that you think has the potential to blow up in a mediation? Are there certain people that maybe you think the mediator should keep apart because there's too much personal history there? That these are the kind of dynamics you really want the mediator to know, not just on the law, but the personalities and things that could be an impediment to settlement. So use the mediator early and often in advance of the mediation as much as you can to be ready so you hit the ground running at the mediation.
I agree 100%. It's an opportunity to build rapport. I know from my work here at NAM, one of the terrific things they will do if the parties want to get some pre-mediation time with one of the neutrals, it's simply a matter of just calling in or sending an email, and they'll put a block of time on my calendar, and we can have that pre-mediation call. I can do it individually, we can do it as a group, but Casey makes a good point. Not enough people take advantage of it. And listen, we're here to provide a service. At the end of the day, we are a service provider. I want to do everything I can to help the parties get their dispute resolved. And that includes, very easily, having that pre-mediation discussion. So let's segue into...
There's a question that came through that. There's a question that came through that may be pertinent to what you're talking about. The question is,
sure.
how do you deal with vastly unrealistic expectations?
Well, that's probably the biggest question of all. So let's tackle it now. It's a process. I would say it's a matter of managing those expectations, beginning with developing a working relationship with the parties. What I, as a mediator, have as my most valuable asset is trust. I have to be able to get the parties to trust me. Now, if I've been fortunate enough to work with the parties before and their counsel, it's something that I've hopefully been able to establish in the past, because I have to have difficult conversations, frankly, with both sides, and ultimately moderate those expectations and have an understanding almost from the get-go that nobody is going to leave the process happy. In fact, I have a little bit of a speech that I give to lay people in order to diffuse unrealistic expectations from the start, and that is to speak to them frankly about the need for compromise, that we are not in a win-lose forum, that both sides are going to have to compromise if we're going to get the matter resolved, that neither they, whatever side they're on, plaintiff or defense, are leaving happy today, but what I try to sell them on is that they get a say in the outcome. So to a layperson, I will say, listen, even though I have to unfortunately promise you you're not going to leave here happy today, the good news is, with the advice and counsel of your attorney, you get a say in the outcome today. And you should have a say in the outcome today, because this is ultimately your litigated matter. However, if we don't get it done today for some reason, someone else will make the decision for you. Some stranger, perhaps a judge. Some strangers, perhaps a jury. But ultimately, someone will make the decision for you. So better you stay in control, knowing from the outset expectations more than likely will be dashed, but if everything works the way I hope it does, with everyone participating in good faith, recognizing their weaknesses, recognizing their exposure, we can leave here today and you can close this particular chapter and have the matter behind you.
Yeah, I agree, and I think not to go back to the same point again, but this is another area where use the mediator early and often comes into play. If coming at it from an outside counsel perspective, if I think my client's view of where the case should settle might be unreasonable because of personal history or amount invested in the case, in addition to trying to control my own clients' expectations through my own discussions, I may have some frank discussions with the mediator and say, my client is not going to very easily resolve this case over X or Y, and this is really what you're going to have to work on with my client in advance. If it's the other side, you could have that call with the mediator, and ex parte calls are perfectly fine in the mediation process, and say the other side is stuck at this particular number but has never supported it, and you need to push on them to provide support for their damages or whatever the issue is that's causing the unrealistic expectations that's causing the parties to be so far apart. Control your own client through your own discussions, but then use the mediator. Clients often listen to the mediator more than us, frankly, because they view mediators as like judges and more independent and someone that they can really listen to. So use the mediator for that purpose. It's a very effective thing.
And that was a great question, and thank you for that. So we'll segue now to the next slide, which is opening statements. Don't pass up the opportunity. So, in my experience, from time to time, I will have litigants come in and say, listen, we know the case, we've lived it for years, we know it inside and out, there are no secrets, let's skip the opening statements and get right down to business. And in fact, I'll be candid, it happened to me this morning on a case. So I will say, geez, that's great. You guys have spent all this time together and you know all the issues as intimately as you do, but I don't. And frankly, I find opening statements incredibly helpful for me as the mediator, because even though I may have reviewed all of the submissions, I always find it interesting to see what points are highlighted, what points aren't, where the nuances lie, because, listen, as we all know, most of these cases have their most interesting attributes in the gray areas, and that's where I tend to focus upon. But even on a more basic level, why would you pass up the opportunity to meet with your adversary and have their client across the table from you to hear your opening statement? Listen, that's one of the great attributes of mediation, is to have the ability to present directly to your adversary's client without anything being filtered through. Now, there are exceptions, of course, if there's a high level of emotion, and we'll talk about this a little bit later on in the presentation, but if one of the parties comes to me and says, listen, my client is distraught, he or she can't be in the same room with their former fill-in-the-blank, former boss, former business partner, listen, I will respect that. It's certainly not the mediator's job to force uncomfortable situations, but this is not an easy process, and you can't have them hide from the stark reality of it. Yeah, so you have to use your discretion in deciding whether or not to bypass the opening statements. I'm going to tell a quick story here, which I think underscores this to a great degree. I had, about a year and a half ago, I was mediating an insurance company bad faith case which arose out of Hurricane Sandy. And it was a first-party policyholder's claim against their insurer for the loss of their home. And as you might imagine, emotions were pretty high. And the plaintiff's attorney came in and took full advantage of the opening round. And again, this was a case that had been litigated fully, discovery was done, the case was on the trial calendar, and yet the plaintiff's counsel came in and did what I would call a Columbo routine. Now, I don't know the ages of our group today, but for those of you who that doesn't ring a bell for, Columbo was a character played by Peter Falk in a television program, I guess in the mid to late 70s, where he played this kind of rumpled detective, dumb as a fox, always kind of scratching his head, but needless to say, solved every crime at the end of each hour as he slowly but surely put together all the pieces of the mystery. And this plaintiff's lawyer walked in, and he didn't do an opening for his adversary. He did an opening for the insurance company adjuster who was there. And like I said, kind of this Columbo routine. He had his papers kind of messily all over the conference room table. And he's kind of asking himself questions as he's going through it. He says, well, I've got this email, and this says this. And then I've got another email from the manager of that department at the insurance company, and they kind of suggest this. And honestly, folks, I was trying not to react, and I'm thinking, this guy is crushing it. And he's essentially showing how he's going to present an insurance company bad faith case to a jury of lay people. And I kept a straight face. I made my notes. We went into caucus. I sat down with the defense attorney for the insurance company and his adjuster, and I said, gentlemen, do you know what we're going to do today? And the adjuster looked at me and said, we are going to settle this case today. And I said, you are damn right you are going to settle this case today. So you can't underestimate the value of an opening statement. So certainly don't pass up the opportunity.
Yeah, and I would just add on that, to Richard's point, think through carefully whether this is the right case for it, and more importantly, what you want to say in the opening statement, maybe to the point earlier about the hypothetical about a case that's strong on liability but not on causation, and that's going to be the big theme of your adversary. Maybe you do an opening statement that really hits very hard all of the key evidence supporting your causation theory, to really go at what you know is one of your perceived weaknesses and something the other side's going to be focused on. And the biggest downside I always hear to opening statements is you're going to offend the adverse client when giving an opening statement. My suggestion on how to avoid that is don't attack the adverse client. Don't make it personal. Just make it about the merits. Make it about the documents. Make it about the law, and effectively address the merits. And you can start with, thank you for being here today. While we all disagree about our respective positions, we appreciate that you're here trying to resolve this. But now let me tell you respectfully why your case doesn't have merit. And go at the merits rather than trying to take shots at the adverse client, which can have the very adverse impact that you're trying to achieve in the mediation.
Exactly. And this feeds very nicely right into our next slide about the absence of decision makers. And again, this can be another failure point for a mediation, for just the reasons Casey and I are mentioning why you wouldn't pass up an opening statement. It's important to have someone on the other side of the table to hear that opening statement. If we don't have the decision makers there, it's very hard, certainly for me as a mediator, to do what I need to do. And a lot of it is in caucus, and a lot of it is, looking across the table, eyeball to eyeball, sizing people up, gauging their risk tolerance, their pain thresholds. And if the client is back at corporate offices and defense counsel or plaintiff's counsel is reporting via phone, oh, let me step out and call the client, it's hard for me to do my job because I've got to get through that filter. Now, will I get folks on the phone? Yes, I'll get folks on the phone. Again, not as good, of course, as having them in the room with me. One step better, which I mentioned to Casey before we got online. I actually mediated a case for his office about a year and a half ago down at their Washington, D.C. office, and it was a very complicated insurance coverage case involving Lloyd's of London, and the stakes were high enough, and to Lloyd's credit, they were committed enough that they had 3 underwriters over in London in a conference room on video conference with me. They were there throughout. Every time I walked in the conference room from caucusing with the other side, there they were. Of course, their attorney was in the room with me. But I wouldn't say it was perfect, but it was pretty damn good, and certainly much, much better than simply communicating, one, through their counsel, or even by me being on the phone with them. So whatever you can do to make sure your client is physically present at the mediation is always going to bode for a more positive result.
Yeah, I would echo that. I mean, typically in the sort of cases where a representative appears in place of the decision maker or even outside counsel, they come with a preset range of authority. In my experience, that's typically never going to be enough. It's the old saying that in a good settlement, neither side is happy, so likely that preset authority is not going to be enough to get a deal done, and there's going to be a point late in the mediation where the mediator really needs to speak to the underlying decision maker. And to Richard's point, and I fully appreciate this because I've done cases for celebrity clients or musicians who have very tough schedules, and it's not always easy for them to be there, but at least build in an opportunity where the ultimate decision maker can speak to the mediator, ideally be able to see the mediator, to Richard's point, by video or even FaceTime you can use these days. There's many ways you can achieve that. So at least when it really gets down to it, if you need a little more authority, the mediator can actually speak directly to the underlying decision maker. It makes a lot of difference.
So our next slide kind of shifts focus back to the attorneys, and we call that wearing trial blinders. And it's something I think all of us as lawyers, particularly me as a mediator, need to focus on, because oftentimes, cases will come to me, literally at the 11th hour. I handled a case, I guess it was last Thursday, that was going to trial this Monday. So at that point, one of the struggles I have is, the attorneys come in, hey, they're in trial mode, right? These guys and gals are in the zone. They've got their arguments lined up. It's hard, and again, this is part of what my job is. It's hard to get them to step back a little bit, because once you cross over into that zone and you've got your trial blinders on, you know what? You've got an answer for everything. You expected that. You're just knocking the ball back across the net every time I try to serve it. But that's not going to help us settle the case. So I think for the lawyers out there, when you come in to mediate a case at the 11th hour, as Casey was talking about when we were discussing preparation, you know what? Do that bifurcated list. Do the strong points and the weak points. Get yourself back into somewhat of an objective mode to the extent you can, even though you may be picking a jury in 48 hours. And to the point of having clients there and clients being a little bit more removed, I will tell you what I tend to do more strategically than not. If I can't get the lawyer to take off his or her trial blinders, I start pitching to the client. Now, they are going to be a little bit more removed. Obviously, it's their money we're talking about at the end of the day, whether they're paying or receiving it. So they may become a more effective audience for me. But the point of this slide, again, within our theme of why mediations fail, is you can't come in with trial blinders on and no anticipation of having to at least take them off temporarily in order to try to negotiate the case.
I agree. It all comes down to being prepared to address your weaknesses. Put yourself in your adversary's position. What will he or she argue, and how are you going to deal with that? And don't just assume that the same sort of response, well, that doesn't have any merit, is going to work. You better be prepared with documents, with new research, to really try to change their mind. You're trying to change the mind of the other side, to move them off of their current position. Otherwise, you'd have a settlement in place. That's what mediation is for. So be prepared to address weaknesses and come up with new ways to attack those weaknesses.
Right, that's a terrific point, because remember, as entrenched as you may be at that moment, as you're getting ready for trial, your adversary is equally entrenched. So as Casey points out, come with ammunition. Make them a little wobbly. Get them a little bit concerned about some of their positions. And it doesn't take much. Just you want to be able to sow some seeds of doubt so that I can then do my job and try to drive a wedge through that and ultimately push the matter towards settlement. So our next slide, ladies and gentlemen, under this rubric of why mediations fail, and maybe no surprise, or that was a bit of a Freudian slip on my part, we don't want any last-minute surprises, right? Here, what am I thinking of? I'm thinking of confidentiality, non-disparagement provisions. I'm thinking of liquidated damages clauses. I'm thinking of payment terms. The things that to one side may seem as kind of an, oh, by the way, we need to pay over 90 days, or, oh, by the way, you of course know we must have a confidentiality provision in this. Well, I'm sure as all of you have experienced at one point or another, that, oh, by the way point for one side can be a deal breaker for the other side. You know what? It's been a long day. Everybody's tired. Everybody's worn out. Everybody's been pushed to and beyond their breaking point. We think we've got a deal in principle, and then somebody throws one more straw on the camel's back, and everything starts to unravel. So, you know, be mindful of that. If you have any requirements along those lines, get them out there early. Now, what do I hear from time to time? Well, if I tell them I need a confidentiality provision at 9:30 in the morning, they think I'm here to settle a case and I'm weak and blah, 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 blah. No, but if that's your concern, then tell me, and I will, in a more balanced fashion, say to both sides at one point or another, once I see us starting to get some traction on the bigger issues, I'll say, hey, does anybody have any conditions to settlement we should get on the table now? I do it almost as a matter of routine at the start of employment cases, because we all know at the end of the day there's going to be an issue about confidentiality. There's going to be an issue about non-disparagement. There may be a request for a liquidated damages clause. So I'd rather get it on the table at 9:30 than at 5:30 when it may blow things up.
Yeah, I actually had a mediation a few months ago where at about 9 p.m. at night the parties finally came to an agreement on a monetary number, and there was a business term that the other side threw in at the last minute, and my client's CEO blew up and said no deal, and it actually became an impediment to a deal. It ended up being resolving down the road, but it didn't get resolved at the mediation because that was something that was never raised before. So it goes back to speaking to the mediator and potentially even your adversary in advance of the mediation. Make these issues aware. You know, maybe to give an example, we're all used to the sort of general release language of releasing all successors, assigns, agents, representatives. Maybe there's some claim against some other third party that you can't release that is subsumed within that language. Don't wait till the end of the mediation to bring it up. Say, assuming we reach a resolution, we can't release the claim against the former manager because there's a separate dispute and they're not paying money, and that can't be part of the release. Bring those issues out early so there's no surprises. Plus, it gives the other side an opportunity to think through how to deal with that concern, and you can come up with some creative ideas around it.
Hey, Kelly, we see we're at a quick break.
Yeah, if I may at this time, I'd just like to take a few moments to read out the CLE code for this event.
Sure, please.
Great, thank you. Everybody, the CLE code for this event is COST23. That's COST23. Again, the code is COST23. Thank you.
You're welcome. So our next topic on why mediations fail concerns emotion and anxiety and not dealing with those in an effective fashion. It's certainly something I try to identify and be prepared for in advance. As a throwback to Casey's point from earlier, this is certainly something I would like to know about before the session, and a well-placed call to the mediator could be very valuable here. You know, I'm on the lookout when we're talking about employment cases, when we're talking about partnership dissolutions, when we're talking about failed business ventures, because everybody may come in pretty wound up and ready to go. So it's a bit of a tightrope for a mediator, because certainly I recognize that part of my role is to allow the parties themselves an opportunity to vent. And I must, because if I don't, the mediation might fail. You know, if the layperson feels that the mediator is not listening, that can really be a moment of downfall for the process. So on the one hand, I have to be, a little bit of a therapist and let people have their say and get off their chest all the ugly things they want to say about their former employer or their former business partner and process it. But here's where the tightrope analogy comes in. I can't let them hijack the process, right? Because that can happen too, and that also can lead to a failed mediation, because sometimes these folks come in with so much anxiety, so much emotion, so much anger that they're looking for retribution and vengeance. And I have literally said to parties, if you are looking for vengeance here, I cannot mediate a vengeance claim. I can never get you the satisfaction you want. The best we are ever going to do, and I recognize perhaps it's incomplete and even unsatisfying, is we are going to be talking about moving U.S. currency from one side of the table to the other side of the table. We are not going to have any moments at which the other side is going to capitulate, and you are going to get some kind of emotional or visceral satisfaction for having beaten your adversary and crushed them into the ground. If that's what you're here for, I can't help you, and we might as well wrap things up now. But again, it's a tightrope I have to walk, because I've got to let them have some space, but as I mentioned, I can't let them hijack the process.
Yeah, and I think, from outside counsel perspective, I think really think through the personalities that you have involved here on both sides and the dynamics, and make the mediator aware of that. Think about who it is you really want at the mediation. I mean, obviously, as discussed, you want the ultimate decision maker there, but are there going to be a bunch of additional people that want to come on your client's side, some of which you think is just not going to be productive? They're going to try to cause problems. They're going to try to use this as an opportunity to embarrass the other side. Think long and hard as to whether you really need all of those people there. Will your client be offended if you say, let's not bring Mr. Jones and Mrs. Smith with us? They're just not going to help the process. And on the other note, think about whether there are people on the other side that do have a good relationship with your client. There might be an opportunity where you let the mediator know, hey, my client really hates Mr. Jones on the other side, but really has a nice relationship with Mr. Williams. Maybe you need to put those two in a room at some point and see if they can talk through some solutions. Let the mediator know in advance, again, going back to the discussing things with your mediator in advance, let the mediator know all these personalities. Let him or her know what really ticks off your client, who's the combustible ones in the room, what's the personalities, the history. Let the mediator know all of that. Give the mediator your suggestions, and that's ways that can help the mediator really deal with those issues in advance of the mediation.
Right, and I'm going to pick up on one of Casey's points and digress for just a moment. In my commercial mediations, Casey was talking about certain representatives from each side that may actually like and respect each other. If that's something I can pick up on, I'm also very happy to say, can this relationship be saved? Because if there's an opportunity in a commercial setting for the parties to continue to do business, listen, maybe they got out of sorts on this particular deal, but were able to work out a resolution, maybe part of an overall bigger picture discussion is, hey, can we put you guys back on track with each other and look towards the future? Because we all know it's always more positive to think about the future and what we might be able to do going forward rather than just the ugliness of the past and throwing hand grenades across the table at each other. So for those of you who are in the commercial arena, I do think that's something to think about with your client. There's always room shouldn't say always, oftentimes there's room to rebuild the relationship, and if you can get the parties into that mode and I can assist as the mediator, it's certainly a much more positive outcome at the end of the day if the parties are able to walk out hand in hand with a future together.
Hey, Richard, here's a question that came through that seems pretty interesting. Or Casey, feel free to to step in as well and answer this. How do you feel about allowing the parties themselves to speak to each other during the opening joint session?
Well, I'll take it first, and then I'll turn it over to Casey. I'll say this: it depends. You have to size up who they are. I never want to cut someone off who feels they have a point to make. Listen, ultimately, this process belongs to the parties. I'm simply there as a means of trying to foster a settlement. So while I have to ride herd a bit, I don't want to look like I'm being controlling or draconian in any fashion. So I look at myself within the context of that question as a referee. So if I think there would be value when one party raises their hand and says, may I say something, and their attorney is okay with it, I'm generally going to allow it. If I see, steam coming out of the ears of the people across the table, I might cut it a little bit short, or I might say, let me talk to you more about that in caucus. But again, starting with the overall view that this is a process that belongs to the parties, I will let them guide me within reason as to how they want to proceed.
Yeah, and from an outside counsel perspective, I think it just depends on the circumstances also. If your client tells you that they really want to start the mediation by making a statement to the adverse client, you better have a real discussion with your client. Why do you want to make this statement? What is it you're going to say? What is it you want to achieve? If it's clearly going to be to smear or upset the adverse client, that's not going to be productive. You should have a real frank discussion with your client on why that's not going to help the process. And if they need to vet, then maybe you just set up a private call with the mediator ex parte. Let your client vet a little to the mediator just to get it off his or her chest. But at least then it's not an open session to the adverse party, which is only going to tick them off and make it that much harder to calm everyone down and move towards a resolution. So it depends on the circumstances, and you have to manage it appropriately.
But that question was a great introduction to our next slide, and that's the use of experts at mediation. And again, putting it within the context of why mediations fail, I certainly believe that not having experts at a mediation where technical issues may be the focus can lead to an unsuccessful session. And I say it somewhat tongue-in-cheek, but we lawyers, when we get involved in technical cases involving issues that are more perhaps appropriate for engineers, because we're ultimately presenting or defending the case, we learn the jargon, we get to speak in a quasi-expert fashion, and I think sometimes our egos get a hold of us and we think we can do it better than the experts themselves, but we can't. And as a mediator, what happens to me is if I'm only hearing the issues as filtered through counsel, I'm not really going to get as good a handle on them as I should, because there's always going to be a bit of a spin factor involved for both sides. Now, the flip side of that is, well, lawyers are very concerned, and rightfully so, that if they bring their experts in, particularly into an opening session, well, they're going to open their guy or gal up to cross-examination, and I'm not going to allow that, et cetera, et cetera. So the balance point for me, when I have a technically focused commercial matter, I'll often ask for the expert reports up front. I'll ask for the experts to attend. I generally will develop a protocol so that the experts can speak at the opening session. I may allow some questioning from the other side. Here again, I play that referee role, but the questions will be limited to factual underpinnings, not necessarily to challenging opinions. And if I think a question is, out of bounds, or it's provocative, or it's just meant to stir up a little trouble, I'll block the question. But even more importantly, in caucus, I want to be able to talk to that expert directly. I want to be able to get a good handle on what the issues are and kind of poke and prod myself as to how well they're going to stand up on certain issues. Again, I think for me, that's private, that's in caucus, not for the open session. But again, to the theme of our webinar today, I do think that the absence of experts in a technologically focused case can be a cause for failure.
Yeah, I really love using expert reports to aid mediation. I use them all the time, submit them in connection with the mediation statement. It goes to the very point before of not just going into a mediation, continuing to make allegations or assertions. You're going in with proof of the arguments that you're making, supported by a valid expert report with a lot of teeth and strength behind it. It's a really effective thing. And for the plaintiff's counsel out there, in a mediation that involves representatives of an insurance carrier and whether they're going to write a big check, I mean, think about the processes that internal insurance adjusters follow and doing diligence on a claim and deciding whether to pay out a policy. They're not going to do it based on allegations in a complaint. They're going to want to see depositions. There's nothing better than putting in an expert report with supportive documents and opinions from an expert supporting the elements of your claim. It makes it that much more effective and easy to try to get an insurance company to pay out. And from the defense perspective, if you have a really strong lack of damages argument or lack of causation, use defense experts to point that out and show that the plaintiff can't meet their elements. It's a really effective thing. Really think hard about the use of reports, or even to Richard's point, bringing the experts to the mediation to talk about those reports. And there really isn't a risk of cross-examination or the reports being used against you down the road, as long as you stipulate in most mediations that anything submitted and used in the mediation is confidential for mediation purposes only. It's considered like a draft report that will never see the light of day in the actual litigation, so you can protect against that concern.
Mm-hmm. So our next slide is labeled Acknowledging Weakness in Mediation. Perhaps we could phrase it as failure to acknowledge weakness as being a block to an effective negotiation. And the point here, and kind of the ethical underlay, is that lawyers have the most difficult time ever conceding anything. And I understand it. We are advocates. We never want to give up an inch of ground. We are there to fight and fight and fight and fight. But in the context of a mediation, if you're not comfortable at least acknowledging a point being of lesser strength, the irony is you end up spending a lot of time defending what may be the undefensible, and you undermine your client's credibility by just fighting for the sake of fighting. Now, one of the strong aspects of mediation is because everything we address is confidential, it can be powerful for a party or their attorney to come in and say, listen, for today and today only, I'm not going to beat the drum on my liability defenses. I have them, you know what they are, but I'm here to get this case resolved today, and I want to focus on my top 3 points, all of which deal with causation and damages. Well, to a mediator, that's music to my ears, right? For a few reasons. 1, we're not going to spend a lot of time on weak points. 2, they're serious about coming here to get this done, and we're going to have a very, very focused discussion on where the real traction in the case lies. Again, I understand it's not an easy thing for lawyers to do, but I'm going to go back again to Casey's point about preparation and preparing that side-by-side chart before you come. Well, what are my strengths? What are my weaknesses for both sides? How am I going to respond to this? How am I going to respond to that? Oftentimes what I will do to kind of test one side's mettle or the other, I'll say, you know what, I've heard everything. Give me your top 3 points on liability. Give me your top 3 points on damages. Let's start to drill down and focus on where the issues really lay. But again, to the point of our webinar this afternoon, where can mediations fail? From my perspective as the mediator, mediations can fail when you're there just to argue every point, every minutia, give up the weak stuff, focus on the strong stuff. You serve your client better and ultimately are much more apt to achieve resolution at mediation.
Yeah, I don't have much more to add on that. I think it just goes back to what we've been saying really throughout the session, which is to be really prepared to address your weaknesses and acknowledge what those are. And if you don't acknowledge them, you're not prepared to address them, and it all goes back to preparation.
All right, we're getting the 10-minute signal here, so we're going to pick up the pace a little bit. We're going to move into 2 slides that are entitled Mediating Multi-Defendant Cases. So for me, as the mediator, nothing is more challenging than mediating a multi-defendant case. Why? Because I've got a room full of, you name it, 4, 6, 8, 10 lawyers and clients. Everybody's got a position. Everybody is blaming the other guy or gal in the room. I can spend 7 or 8 hours among and between the defendants and then unfortunately tell plaintiff at the end of the day, oh, I'm awfully sorry, but I don't yet have $1 to offer you because I cannot get the defendants into sync with each other. So what I often suggest, if the parties, and you know when you are involved in that kind of a case, call ahead of time, set up a defense-only mediation. I would much rather spend the day and evening with you rather than having a plaintiff and his counsel cooling their heels all day in another room. Their frustration and resentment is only going to build. They don't even need to know we're having a mediation. You could be doing this as a means of simply testing the water among and between the defendants to see if there is a means of coming to some resolution. If you look at, I guess it's the first slide of the 2. Let me just check. The second slide of the 2. I've got a little bit of a protocol there. I won't go into detail, but what I have there, I wouldn't call it a checklist, more of a flow chart perhaps, as to how do I attack a multi-defendant case when my goal is to try to get the defendants to agree to percentage allocations among and between each other. And that certainly is always the goal. I would much rather come to a mechanism, a working model, where we have the defendants agreed to allocation by percentage. Then, when it's time to sit down with the plaintiff and their counsel, I can keep the defendants together. I can take ammunition from them as a group to use with the plaintiff, and they can negotiate with one voice. Now, that's the ideal. That doesn't always happen. My fallback, if I can't get the defendants to agreed percentages, plan B is generally to take dollar offers individually from the defendants, but the problem with that is as I do that and the defendants hear what their co-defendants are putting into the pot monetarily, they do the percentage calculation in their head, and then things generally go off the rail because they know what they're doing in relative terms to the others. So plan C is I do blind bidding, and I go around and I meet with each defendant separately, and I ask them to bid on their perceived exposure. I do not tell them what their co-defendants are putting in the pot. I do not tell them what the group offer is. I do tell them what the global demand is coming back in response to the offer, and then I ask them again to bid based on their own perceived exposure against that reduced demand. I will tell you this, it is a lot of fun until the big reveal, and then somebody's really unhappy because they overbid. So what I do to try to avoid that is once I get pretty close and I've got a sense of what is achievable, I will go around and meet with the defendant separately and say, look, if you give me X number of dollars more, I'm going to tell you this, the case is settled. And I will try to work the figures a little bit if I see any really obvious inequities, because I certainly don't want someone to feel that they were somehow bamboozled into making an offer. But again, it's only because I couldn't get them to allocations on percentages. The last option I use, and then I'm going to give Casey the opportunity to touch on this topic, is I will say to the defendants, if I can get to a number with the plaintiff that you all will begrudgingly say, it's an okay number, but you'll say, but I don't want to pay towards it, or I don't want to pay too much towards it, I will suggest to the defendants, look, if this is a matter of you all just not being able to make the decision among yourselves, well then you know what? I'll negotiate for terms with plaintiff. I'll get a commitment that they won't get paid for 120 days, let's say, but they know what they will be getting in 120 days, and then I'll suggest to the defendants, you know what? Arbitrate the allocation. If you guys can't make the decisions yourself, let a well-known, experienced arbitrator hear your arguments, read your papers, assess your positions, and make the decisions for you. It's certainly better than going on with continued litigation, especially with the plaintiff in the case. You've already all agreed the number's not terrible, and you're just having difficulty among and between yourselves deciding how to allocate it.
Yeah, I'm just not a big fan of mediation with too many people. I've seen it be a big problem for the mediator to control the room with so many people talking, so many personalities. Really think hard as outside counsel, as a client, who really has to be at the mediation, and don't overkill it. On the defense side, try to designate one person who's going to speak on behalf of the defense group. You can have private sessions among the defense group. It's just not helpful to have 8 different people in a room talking to the mediator. It just makes the mediator's job that much more difficult.
All right, so I think we're on to essentially our last slide. We're probably just out of time. So this one is entitled Mediator Proposals. Be careful what you wish for. I do not believe in mediator proposals. They are absolutely the last-ditch Hail Mary pass I have if I can't find another tool in the toolbox to get the case settled. And the simple reason is as follows: because someone will seize on that suggestion, that figure, and hold it in a death grip and say, see, that's what the mediator recommended, and the other side will balk, and it's simply not, to me, the best way to resolve the case, because frankly it leads to more mediations failing than succeeding, at least in my opinion. I will not give parties an opinion on what I think a case is worth, because I don't think it matters what I think the case is worth. I will give an opinion on what I think the case can settle for, which is a very different question and calls into the equation everything I have learned that day. But whenever a mediator, at least I believe, interjects their personal opinion, their personal views, they put themselves on a path for trouble.
Yeah, I would just add in closing, sort of in that scenario, end of the day, end of the mediation where it looks like settlement's going nowhere, just pull your mediator aside and use their experience. Ask them what they think could be helpful before everyone leaves. Could a mediator proposal be helpful? Sometimes maybe the mediator would ask each side to make a confidential final proposal, which he or she won't relay to the other side unless it results in a settlement. There's ways to creatively address a tough situation like that, draw on the mediator's experience, who has a pretty darn good idea of how far each side's going to go by the end of the mediation.
Exactly. Kelly, how are we doing on time? Any questions?
We have just about reached the top of the hour at this point. Thank you very much, Richard and Casey, for your insights today, as well as Law.com for their support. We'd like to thank everyone for joining us. We hope this discussion was very useful to you. Please note you will all receive an email notification when the archived webcast is available for reference. Thank you again, and have a great afternoon.
Thank you.
Thank you.